The date is July 22nd, 2024. The time is 1:30 p.m. I'm going to quickly do a roll call, see who's present, and then we'll go ahead and get the proceedings started. So I'm going to start first with those participating on behalf of FSEC. I do have some names on the board, so I'll confirm that you are present, and then we'll go around and see if I missed anybody. So starting first, I see Andrea Grantham is present. Ms. Grantham, are you present?
I am here, yes.
Thank you. Catherine Taliaferro.
I am present.
Thank you. Adrian Barker.
I am present.
Good. And Joan Owens.
Present.
Lisa McLean.
Present.
Thank you. Audra Allen.
Present.
Lance Caputo.
Yes, sir.
Good afternoon. Allie Smith. Allie Smith, I see you on the screen. Left is FSEC. Are you present, or just not on mute, or kept me on mute rather? Move on. Martin McMurray.
Present.
And anybody else on behalf of FSEC at this point who either I have not identified or who has not identified themselves. So go ahead and state your name for me, please.
Yeah,
This
hi,
is
this
Alex
is
Shiley.
go ahead.
Sorry. Alex Shiley is present.
Thank you. Thank you, Ms. Shiley. Thank you. And Mr. Thompson, I know you're Assistant Attorney General. Go ahead and please announce in what capacity you are here with FSEC.
Yeah, hi, this is again Jonathan Thompson. I am FSEC's assigned Assistant Attorney General legal advisor, so not appearing in the case, but just listening in, and I'll be advising the council in this matter. Also, I believe Jenna Slocum, in the same capacity, is here as well.
Yes, I'm present as well. Thank you.
Excellent. Anybody else currently present on behalf of FSEC? Again, as either I have not identified or who has not identified themselves. All right. We will come back to determine if Allie Smith is on the call or if it's just a placeholder. I'm not quite sure what's going on.
Oh, I apologize. I am here. I'm here on. Yeah, my name is Allie Smith. I'm here as an observer for FSEC.
Very good. Thank you. All right. So with that, let's move on to the next party with the applicant, Wautoma or Interjex. Do we have any representatives on the behind of them? If so, go ahead and state your name, please, and what role you're participating in.
Hi, I'm Laura O'Neill with Interjex, with the applicant. I don't see Erin Anderson on yet, our attorney, unless she is that unidentified phone number. So
good afternoon. This is Erin Anderson.
Oh, you are that phone number. Fantastic. Thanks.
Thank you. And Ms. O'Neill, and what is your relation with the applicant? I don't see a title or anything. I know Ms. Anderson is the attorney of record. Go ahead.
Yes, I'm an employee of the applicant who's been working with FSEC on this file.
Okay. And Ms. Anderson, anyone else besides you and Ms. O'Neill participating in today's pre-hearing conference for the applicant?
Your Honor, I may also have one of my colleagues at Van Ness Feldman. His name is Andrew Lewis, although I will be speaking for the applicant.
Okay. Mr. Lewis, are you on the call?
Yes, this is me on the call, Andrew Lewis. I'm having trouble joining visually, so apologize for the delay.
No, actually, none of us are joining visually. No one's appearing video. It's the audio portion, though we can have small little icons of everyone's initials. That's how I know everyone's here. So you're not missing anything by participating exclusively over the phone.
All right. That explains it then. Thank you. It is good to be here.
Very good. Thank you. All right. Then let's move on to the other participants who I received notification from as to their intent to participate, starting with Benton County. Do I have someone on the line on behalf of Benton County?
Yes, this is Leanne Holt. I'm an attorney with the Civil Division of Benton County. And I believe on the line we also have Michelle Mercer, our planning manager, and Greg Wendt, our director of community development.
Let's go. Just writing this down as we go. So I may have to repeat those names. Ms. Mercer, are you on the call?
Yes, I am.
Very good. And Mr. Wendt, are you on the call as well?
Yes. Thank you.
All right. Who is going to, I'm sorry, Ms. Holt, are you representing Benton County in today's proceedings?
I am.
I didn't actually receive a notice of appearance from you. I received it from Eric Eisinger. Did you send one, or did I simply overlook that you are an attorney of record for this matter?
I should be an attorney of record in this matter. I'd have to double check, but I believe the notice of appearance has Eric Eisinger and then me as the undersigned attorney for appearing for him.
Okay, we'll go ahead, and you're an officer of the court, so obviously you can participate today based on the representation. If after the proceedings that there is not a proper notice of appearance, I'll need you to send one. If there is, I'll go back and double check. Then obviously you don't need to do anything with the follow-up. But I just need to make sure who's speaking on behalf of Benton County today.
That would be me.
All right, very good. And Ms. Holt, anyone else besides the three of you on behalf of Benton County?
Not that I'm aware of.
All right, thank you. Let's move on next to the next participant, which was the Council for the Environment. Do we have anyone on the line on behalf of that agency?
Yes, Sarah Reineveld, Managing Assistant Attorney General, is participating today on behalf of my colleague, Yuri Korol, who's the assigned Counsel for the Environment in this matter, but unable to join us because he's on vacation.
Okay, and Ms. Reineveld, are you acting just as a representative in this pre-hearing conference for scheduling and whatnot, or are you also intend to participate further down the line?
Just as the representative for this pre-hearing conference, Your Honor.
Very good. And anyone else besides you on behalf of the Council for the Environment?
No, it's just me. Thank you.
Okay. All right. I'm going to see if I can pick out who else has not been named and what they're here for. I see Linnea Fossum. Would you please tell me who you are and what your point of participating today is?
Yes, Your Honor. I am employed by Tetra Tech, which is a consultant to the applicant, and I'm just here to observe.
Would you spell the name of your company, please?
Tetra Tech, Tetra Tech.
Right. And rather than trying to piece together who I have or have not called, is there anybody else in the call either I have not identified or who's not identified themselves before we begin?
Yes, hello, this is David Witt. I'm an assistant state archaeologist with DAP. I'm just observing.
Thank you, sir.
And this is Amy Hofgemeyer from FSEC.
Right. Well, thank you all for your patience while we did the rather lengthy roll call. Now that we do have everyone announced, let's go ahead and discuss the purpose of today's peer hearing conference and then get into the issues themselves. So during this conversation, we're establishing the issues, disputed or otherwise, and issues related to the adjudication. I'm going to speak mostly to the three parties of interest. Interjects Renewable Development, or at least the parties of interest who have declared their intent to participate. So I'll be speaking mostly to Ms. Anderson, Ms. Holt, and Ms. Reineveld. Obviously, when there are scheduling issues, we'll consult with the other parties, including FSEC for the council's availability, and then any other parties wish to interject, depending on how far it goes. We'll see if the point has merit. So with that, the purpose of today's pre-hearing conference is to first to determine if there are any issues that are ripe for this adjudication, which can be stipulated to streamline the process. If we can articulate, if everyone go ahead and put yourself on mute real fast, just so we're not getting background noise. Thank you. We can first identify if there are any issues that can be stipulated to by the parties. Whoever the 360772 number, would you go ahead and put yourself on mute, please? Thank you. As I was stating, first to determine if there are any issues we can stipulate to, so we don't need to rehash information and draw the process any longer than further than necessary. Then to discuss if there are any outside of the articulated issues, if there are any other disputed issues that need to be addressed. Once we have framed what the issues are, at least the issues in dispute are, then we will discuss how long the parties believe they're going to need to present their case in chief, when parties will be available to hold the hearing, and then any other pre-hearing issues that need to be discussed ahead of time, such as potentially discovery. So in the order commencing adjudication that was mailed to all parties, the broader issues is framed in that order commencing adjudication, or whether the council should recommend to the governor that the state preempt the land use plan, zoning ordinances, or other development regulations for the site for the alternative energy resource proposed by the applicant, and if the council approves the applicant's request for preemption, what conditions the council should include, if any, in a draft certification agreement to consider state or local government or community interest affected by the construction or operation of the alternative energy resource, and the purpose of laws or ordinances or rules or regulations promulgated thereunder that are preempted pursuant to RCW, that is Revised Code of Washington, 80.50.110, subsection 2. So those are the broader issues that we are dealing with. I'd like to start first with if there have been any preliminary discussions amongst the parties as to any issues that may be stipulated to ahead of the actual hearing. So, Ms. Anderson, we'll begin with you. Have you had any discussions with either Benton County or the Council for the Environment about possible stipulated issues ahead of today's pre-hearing conference?
Good afternoon, Your Honor. No, I have not had any conversations with them about whether there are stipulations relating to these two issues. We have had discussions about whether there are other issues to add.
Okay. In the, I believe it's a notice of pre-hearing conference, we did set out 4 requests of the parties to prepare ahead of time. And one of those was issues within the scope of topic for adjudication, which are ripe for stipulation to streamline the hearing. Had you made a list, at least for yourself, of any of those issues that we can discuss today with the other 2 parties? Or have you not reached that part of your preparation yet?
Your Honor, the applicant would be happy to stipulate to issue 1, but I would defer to the county and CFE as to their agreement to stipulate to issue 1.
All right. Ms. Holt, we'll begin with you. Does the Benton County wish to stipulate to issue number 1 and limit the adjudication to issue number 2?
We would like to present and discuss whether or not the council should make that recommendation to the governor. We would not stipulate that the council should at this time.
Okay. Very good. So, Ms. Rainebold, obviously, if there's no agreement at this point between those 2 parties, whether or not you're going to stipulate to is sort of a moot point at this.
That's correct.
Okay. Ms. Anderson, were there any specific factual issues outside the broader issues that you would, the applicant would be willing to stipulate to, or at least discuss stipulating to, so that evidence doesn't need to be put before the board if everyone's going to present the same facts?
Yes, Your Honor. I have spoken with the counsel for Benton County, Ms. Holt, regarding a stipulation of fact and had explored a filing deadline to submit a stipulation, if we can reach a stipulation, to submit those agreed facts August 13th, or at least 1 week before opening of pre-filed testimony, wherever that date lands.
Okay. And Ms. Anderson, those conversations would also need to be held with the Council for the Environment too, as they are the party to this. It's not simply between you and Benton County. Are you aware of that additional?
Yes, Your Honor. Yes, and I shared those dates with Ms. Reinebold and Mr. Carroll. Ms. Reinebold returned from a 2-week vacation today, and she has a copy of this, but she has not had an opportunity to speak with Mr. Carollo, who is going to represent CFE on this case. He is on vacation now.
Okay. And Ms. Randall, is that your understanding of where we are with this process?
That's correct. I don't know to what extent Mr. Krill has participated in conversations regarding stipulations, but we would request that Council for the Environment is a full participant in those conversations moving forward.
Okay. And Ms. Holt, do you agree with Ms. Anderson that there was a discussion about possibly setting the stipulation submission to August 13th?
Yes, we agree with that.
Okay. Ms. Randall, if we did build into the calendar, just preliminarily at this point, a stipulation deadline of August 13th for the parties to mutually agree upon something and submit both to me and as well as the council. Would you agree with that date?
Yes, that date is agreeable, as I communicated to Ms. Anderson to Council for the Environment.
Very good. But I was hoping to get some more concrete issues nailed or set aside because it's going to impact how long we're going to take for the hearing. I think if we can get it done before the hearing, that even if we schedule too long of a time, it still will shorten the process. So we'll set the stipulation agreement deadline, if one is reached with all the parties, as August 13th. Let's move on then to the secondary need, which is discovery. Now, this matter has been obviously before FSEC for a few years at this point, and I really don't see what discovery would be needed that hadn't already been done or could have been done ahead of scheduling this pre-hearing conference. But I'm also not going to preclude some presentation of their case if those discovery needs are legitimate. So starting first with Ms. Anderson. Ms. Anderson, are there do you anticipate any discovery deadlines or any discovery conferences that will need to help other parties? Or is that something that you believe you and the other two parties can handle informally as you're all attorneys?
Your Honor, I don't believe we need any discussion in this, discovery in this matter.
Okay. And Ms. Holt, does Benton County have any take one way or the other on discovery?
At this time, I don't foresee a lot of discovery being needed on our end. I would like to keep that option open, however. I think that's something that can be handled between the parties, but if the court would prefer to impose a deadline, that would be fine with us.
My preference is always to have the parties work out informally. That way, no one feels that they're being strong-armed. Usually you can get a better result when people work collaboratively, though obviously I have an option for motions to compel if those discovery discuss or requests do fall through. So, Ms. Randall, will the Council for the Environment request any discovery intervention on behalf of myself?
Council for the Environment does not anticipate conducting discovery in this matter. Thank you, Your Honor.
Perfect. Okay. Then let's move on to how long everyone believes they're going to need to present their case. And that will obviously frame how long we're going to need for the totality of the hearing, and then will also help us in finding dates that work for everyone's calendar. We go into this understanding that those potential stipulated issues may be resolved ahead of time and not accounted into the overall the places people would need to hold their hearings. But I think at this stage, it would be better for everyone to anticipate nothing is going to be stipulated to, and we have more time in our hands than not enough. I think that's a better practice. So, Ms. Anderson, with that, how long will the applicant need to present their entire case in chief? Now, previous adjudications before FSEC or most recent adjudications have done pre-hearing written submissions of direct examination. I'm not going to do that in this particular one. I think given the fact that there aren't as many parties and the issues are relatively straightforward, I think a better use of everyone's time is simply to have everyone present their witnesses, have them sworn in, and take direct examination before the council and myself, allow for cross-examination and redirect at that, rather than artificially extend the deadline with written submissions and then exclusively deal with cross-examination at the live hearing. So, long explanation. Ms. Anderson, how long do you believe that the applicant will need to present the entirety of their case in chief?
Well, we had prepared for this pre-hearing conference exchanging schedules that contemplated pre-filed testimony in order to expedite the actual time needed at the proceeding. If we are not going to be doing pre-filed testimony, response and rebuttal, I would need a full day to present our case in chief. If we do pre-filed, I would need a half a day.
No, at this point, we're going to go ahead and just do the no pre-filed, no response rebuttal. Just treat it as a normal hearing. I think that's the best use of everyone's time. So 1 day, you believe, and that's, yes, ma'am, go ahead.
If I may, I do want to revise my response. I understand that you didn't see the need for discovery and you don't see the need for pre-filed, but I am going to change my position that we do indeed want to leave discovery open. I'm willing to work collaboratively with the parties, but I will not go into a hearing without discovery or pre-filed. I will need to reserve one of those. So discovery it is.
Okay. I will not set a deadline for discovery. I will leave the parties the ability to work collaboratively together. If those collaborations do fail, simply reach out to my office and request a status conference, and then we can meet with the participants to determine where we are with the discovery, what potential solutions we can do, if it will affect the deadline we're setting. But at this point, I'm not going to build in an artificial deadline if it may not be necessary.
And I would respectfully ask the court whether the other parties are interested in pre-filed testimony as an alternative to discovery, as a means of shortening the adjudication time itself.
It'll shorten the adjudication time, but lengthen the period that we have to actually get to adjudication. So that's the front end that I'm concerned about, because oftentimes that will belabor the point for 2 or 3 weeks while people submit those. While it shortens your presentation by a half a day, it extends the resolution of the overall recommended order by a significant period of time. And that's my aversion to building in those deadlines.
And I understand that the parties have exchanged a proposed schedule for pre-filed testimony that allows us to have an adjudication in the window that the court had asked us to consider. That's the position that we're coming from. So,
okay, Ms. Holt, would you like to add to this issue?
Yes, I did discuss that with Ms. Anderson last week. Benton County is also inclined to request written submissions in advance, and we were aware of the timelines proposed by Ms. Anderson and are in agreement with that as well, if the court were so inclined to allow that.
Ms. Reynolds?
I would defer to the other parties. Council for the Environment does not anticipate presenting its own case in chief in this matter, but may reserve time to cross-examine witnesses.
Ms. Anderson, what were your proposed deadlines? You and Ms. Holt had discussed them.
Sure, Your Honor. What the parties had done is we looked at the window of time that the notice of pre-hearing conference instructed us to look at, and found that with the exception of October 4, the parties are available the week of the 29th of September through the 3rd of October, recognizing that the council or Your Honor may not be, but we chose a date, October 1, and worked back from that to identify a proposed pre-hearing brief schedule, requirements for pre-filed opening, response, and reply, as well as the deadline to submit stipulation of facts, so that the stipulation of facts comes in on August 13th, that the parties opening pre-filed would be due a week later on August 20th, that responses would be due 2 weeks later on September 3rd, and replies on the 10th of September, and recognizing that there may be motions to strike, proposing that motions to strike would have to be filed 5 days from the pre-filing submittal, and a response 3 business days from the actual filing of the motion. We didn't propose, or I didn't propose, any oral argument on motions to strike. I think those have traditionally been handled by the judge. And really within 3 business days from the response. What that did when we were talking about this is it put all of the pre-filed testimony into the FSEC record by September 10, And were we to go out hypothetically on October 1, we would have 2 weeks to complete pre-filed briefs or pre-hearing briefs on September 24.
Ms. Holt?
That is my understanding of the schedule, and we would be all right with that.
Usually I try to accommodate the parties' requests. In this matter, we're going to keep it just with the presentation of the cases without the pre-filed testimony. Stipulated facts, we'll agree to that part. But in this particular case, I'm going to have everyone prepare their entirety of their case in chief and present it to them when we actually get to the hearing. So your recommended schedule is I'm not going to adopt. Okay, so one day for the case in chief, Ms. Anderson. Ms. Rainevald, you did say just a moment ago that you don't anticipate the Council of the Environment presenting a case, but you still wish to reserve the ability to cross-examine. Is that correct? Is that your position?
That's my position. Yes. Thank you, Your Honor.
Okay. And Ms. Holt, how long will Benton County need to present their entire case in chief?
Thank you, Your Honor. I wasn't quite prepared for that calculation. We only have 2 witnesses. I anticipate the 2 witnesses probably would not take more than an hour each, probably less than that.
Now, obviously, I will have the opportunity to question the witnesses, and so will the FSEC counsel. If we schedule this matter for its entirety for 2 consecutive days, Ms. Anderson, do you believe that would be sufficient time?
Yes, Your Honor.
Ms. Holt?
Yes, I believe so.
Ms. Randall?
Yes, that should be sufficient. Thank you.
Okay. Now that we've nailed down at least the anticipated or the expected presentation of the testimony as well as the dates, let's talk about everyone's availability. And then once we get the hearing down, we will work backwards with a witness and exhibit list deadline that will be required of everyone. Given again that there are not many parties involved in this proceedings, I'd like to get this done as obviously sooner rather than later. Ms. Holt, you put yourself on mute really quick until we need you. I'm getting feedback from your line. Thank you. We have the stipulated agreement deadline of August 13th. I'd like to look in the first week or first 2 weeks of September when parties will be available. Ms. Anderson, if we start looking for 2 days in early September, would that be ample time for you to prepare your case in chief and present it to the council?
No, Your Honor, I'll need more time than that.
And for what reason will you need more time?
My client won't be available, and I'm going to have to reorganize the way we're going to be presenting information rather than in a pre-filed. And even with the pre-filed, I didn't anticipate being ready by the beginning of September. Because we don't have pre-filed, I'm going to be doing some discovery.
Ms. Hofgemeier, you have your hand raised.
Yes, thank you. I know that we have some information on council availability for those timeframes, and I'm wondering if it would be helpful to identify those dates for the parties to consider.
Yes, go ahead and propose them, and we'll see if it works with everyone's availability. So go ahead, and then if it doesn't work with mine, I'll certainly chime in.
Okay, I will also post them in the chat so that people can read them. But we have for council availability in August, the 16th, 26th, 27th, 29th, and 30th. For September, we have the 17th, 23rd, 24th, and 25th. In October, the 10th and 11th.
All right, we'll give you a minute to go and put that in the chat, and then we'll see. Ms. Grantham, go ahead.
Yes, I would advise to take off the 29th, as I was reminded that we are also looking at for something else on FSEX Matter to schedule on that day, so that day would probably not be the best day for the council. That is August 29th.
Okay, I think it's the parties have made it clear they're not going to be ready sometime in August, so I think those dates themselves will just be stricken. So we'll look towards the second batch of dates and see if there is availability. So, Ms. Anderson, do you have access to the chat and do you see the dates posted by Ms. Hofkammer?
I've looked away. I'm looking now. One moment.
I can read them too if you prefer. It's
That would be
neither
great.
here nor there.
Sure.
Very good. So as I said, we're taking August off the table based on your representations. But they have September 17th and then September 23rd, 24th, or 25th, or October 10th through 11th. Of those dates, are you and your witnesses available and be able to participate in any of those, preferably 2 consecutive days if possible?
I am going to ask the project manager on this case. Her husband is Australian. She will be in Australia, I believe, from the 20th, and Ms. O'Neill is on the call from the 22nd of August to the 22nd of October. So the 17th, and let me look here.
Yeah, thanks, Erin. I can jump in. This is Laura O'Neill with the applicant. Yeah, the availability conflicts we had, Ms. Anderson had proposed with the other parties, ideally the week of September 30th, as I am traveling internationally and am not traveling home until September 23rd. So turning around to go straight into hearings the next day is not feasible on our end.
Are you going to be a witness, Ms. O'Neill? Is that why your participation is necessary?
That's correct.
So, Ms. Anderson, are you telling me then that the only days you're available would be, at least reporters, her availability would be in October 10th or 11th?
She is available then. I'm in New Zealand that week.
I'm sorry, you broke up. You're busy into that week, is that what you said?
I'm in New Zealand the week of the 10th and 11th of October. Let's have a look at the 29th. If I can get some discovery done, it's possible we could do this in one day on the 29th.
Is that September 29th?
Yes.
The council may not be available. Ms. Hofkammer? Sorry, Ms. O'Neill. Let's fit Ms. Hofkammer first, Ms. O'Neill. We'll come back to you. Otherwise, it gets confusing.
That's correct. We don't have September 29th listed as a date that the council has indicated they're available.
Ms. O'Neill, you're going to add something?
I was going to add that September 29th is a Sunday.
Oh.
So if council availability is on the 30th or October 1st, that could work.
I don't think it's going to work for FSEC council. Ms. Hofkammer, just I want to know what flexibility we have outside of the dates that you proposed, if any.
So we can reach out to council. There may be other dates available, but we would be missing more of the council members, which isn't ideal. They could watch recordings potentially to catch up.
But it leaves it doesn't give them the opportunity to, well, I have to pause with that because it doesn't give them an opportunity to question the parties in live time, which is a requirement that they have that opportunity. So I'm not unwilling to have council rely on recordings if it's going to handicap their ability to make an accurate and complete decision.
Ms. Hufkemeyer, is the council still available on the 25th of September?
Yes.
Okay. And we did propose it for 2 days, though a majority of that time was built into as a buffer. If the parties legitimately believe we can complete this in 1 day, and if need be, finish it up on a second day to be discussed after the end of the 25th, I'm open to that. Ms. Anderson, if we set this for September 25th?
I'm open to that as well, Your Honor.
And Ms. Holt?
So my witnesses are available on September 25th. I do, however, have one of my witnesses. She's going to be gone on the 26th. So I have not heard back from her on whether that would be an issue for her. Maybe Mercer could speak to that.
Right now we're not contemplating blending into the 26th, just holding the entirety of the hearing on the 25th. And then at the end of that hearing, if we need more time, then we can coordinate amongst ourselves when we can meet next. It's not it's not ideal to split up proceedings, but if we can get it on the books earlier, I think that's, and then roll the dice that we're not going to need the 26th. I think that's the best tact. So with just the 25th, are you and your witnesses available?
Yes.
Perfect. Ms. Randall?
Yes, that should work for Mr. Corral and Council for the Environment.
Okay, very good. And Ms. Hoffman, just to confirm, so before we get too much further, the council in their entirety, or most of them at least, can participate on September 25th. Is that correct?
That is correct.
Very good. All right. So the hearing, per the council's request, will be set over a Teams video rather than in person. So we will hold it much like we're doing today, except with the video component, on September 25th. I like to start early, but most people don't like to start their day at 8 o'clock. So if we did it from 9 a.m. to 5 p.m. with a reasonable break in between, Ms. Anderson, would that work for the applicant?
Yes, that works, Your Honor. I'd be interested in knowing if you are wanting us to go fully through and put the public comment periods at the end or in between. I just want to make sure that if we agree to this, that the time for the parties to present isn't shortened by the need to have public comment.
Sure. Ms. Afkamar, you were going to add something?
For public comment meetings, FSEC traditionally holds those after the traditional workday 8 to 5 to allow members of the public to come speak after their workday. So for Horse Heaven and for other public meetings, the public comment portion has happened in the evening.
So Ms. Hawkins, just for sake of my understanding, in the Horse Heaven project, those public comment section, were all parties, including the judge, were they present during those public comments, or were they simply made available to review after?
I don't recall. I'm sorry. I'd have to go back and look. I can do that and get back to the group.
Thank you. Go ahead and do that real quick then. All right. So we'll set that issue aside for now. But going back with the proposed times, Ms. Holt, if we did it from 9 a.m. to 5 p.m., would that work for Benton County?
That would, Your Honor.
Good. Ms. Reynold?
Yes, that will work for Council for the Environment. Thank you. Okay.
And there are other people who are going to participate, including the AAGs advising, the FSEC, Mr. Thompson and Ms. Slocum. Would you be available to observe in whatever capacity you are on that date and time?
Yes, that works for us, or for me.
Ms. Slocum?
Yes, thank you.
Okay. All right. So from that, we're going to discuss next the pre-hearing brief and witness and exhibit list deadline for all parties. Customarily, I set those witness and exhibit list deadlines that submitted to all parties of interest, including myself and the council, 2 weeks prior to the evidentiary hearing, which would put us near the first, about the 11th of September. Give me just a moment. Ms. Anderson, would the 2 week prior to the evidentiary hearing work for the applicant, or would you prefer a week on the same day we're going to set the pre-hearing brief so you have more time to prepare?
The 11th is fine. Thank you.
I'm sorry, you're very soft spoken. I didn't hear that at all.
September 11th is fine, the 2 weeks.
Oh, thank you. Very good. Ms. Holt, would the witness exhibit this deadline at September 11th work for Benton County?
It will.
And Ms. Randall for Council for the Environment?
Yes, that date will work. Thank you.
Okay. And within my pre-hearing conference order, I will give instructions on how to properly label and submit the documents to the other parties. So the next deadline we're going to set in will be the voluntary hearing brief, or pre-hearing brief, if you will. Strictly voluntary. Nobody is required to submit one. We'll set that 1 week to prior to the hearing of September 18th. Sanderson, does that work for you?
Yes, it does. Thank you.
Ms. Holt?
Yes, it does. Thank you.
All right. And Ms. Radevold?
Yes, it does. Thanks.
Okay. A few final questions for the parties, and we're going to go around and see if there's any final questions. Ms. Anderson, will either you or any of your, obviously not you, but any of your witnesses benefit from the services of an interpreter in these proceedings?
No, sir.
And will either you or any of your witnesses need any reasonable accommodations to meaningfully participate in a video hearing?
No, sir.
Ms. Holt, same 2 questions for you. Will either you or your participants need either an interpreter or any reasonable accommodations?
I do not believe so.
Very good. Ms. Randall?
No, I don't anticipate that.
Okay. So let me briefly recap what was discussed and see if there's any final orders of business, and then we'll go ahead and end today's pre-hearing conference. Just a moment while I write this down, please. All right. So the parties have agreed to set the stipulation of issue deadline as August 13th, 2024. All deadlines are by 5 p.m. Pacific. The parties have agreed to hold the evidentiary hearing over video format on September 25th, 2024 from 9 a.m. to 5 p.m. The witness and exhibit list for all parties will be September 11th, 2024, also by 5 p.m. with a voluntary hearing brief of September 18th, 2024 by 5 p.m. The parties, none of the parties have indicated they will benefit from the services of an interpreter or any reasonable accommodations. Ms. Anderson, do you agree that was discussed and what we agreed upon today?
Yes, I do.
Ms. Holt?
Yes, I do.
And Ms. Randall?
Yes, that's correct. Thank you.
Okay, then following today's pre-hearing conference, I will issue my pre-hearing conference order with everything we did discuss, including the proper witness and exhibit labeling, just so to avoid confusion. Those are all the things I wanted to discuss today. I'm going to start first with FSEC to see if there's anything else we need to discuss. There's a couple people on right now that need to speak, and then we'll go around the horn to the actual participants. Ms. Holt, we'll come to you second. Let's start with Ms. Hoffmeyer.
I don't have anything else to be discussed today, but I did want to confirm that the council and judge were present at the Horse Heaven public comment meeting associated with the adjudication. So that will be our plan for this hearing as well.
Okay, thank you for that. If that's the case, that's something we probably should build in, at least a tentative deadline. When do you anticipate setting that meeting, or is that something I will need to establish? Ms. Hoffmeyer, you have to forgive me for my unfamiliarity with those nuanced practices.
We will look at the calendar and set dates and notice, but we will certainly reach out for scheduling and availability.
Thank you. Then I will not include it in my case schedule. That is the case. All right. Anything else we need to discuss, Ms. Hoffmeyer or Ms. Grantham? I'm not sure who's speaking on behalf of FSEC at this point.
Nothing else from FSEC. Thank you.
Thank you. Ms. Holden, you have your hand raised. Go ahead, please.
Yes, I just wanted some clarification. We did review the issues that were going to be discussed as listed in the initial order commencing adjudication. And I just want to, I guess, make a record or ask for a clarification that since those are quite broad, Benton County would like to reserve the opportunity to discuss things like environmental impact, cultural impact, societal economical impact, and the cumulative impact of the preemption and approval. I think it could kind of fall under both should the council preempt, and then what conditions may need to be imposed if the council does so make that recommendation. But I just wanted to check.
Well, I can't tell you.
Oh.
Yes, go ahead, please.
FSEC has deliberately and purposefully limited this adjudication to land use alone, and land use is the county's comprehensive plan and development code. The matters of environmental, socioeconomic, economics, cumulative impacts, and the like fall under the ambit of different topics. Those are SEPA, the State Environmental Policy Act, as well as different segments of the FSEC regulations. I don't believe it's appropriate to, at this point, reopen the council's decision about limiting the topics to land use, with all due respect.
Ms. Holt?
And this matter received a mitigated determination of non-significance that has not been appealed. So we have a decision already from the council that the impacts of this project on each of those topics is not significant.
Ms. Holt, could you describe to me how that would be revisiting those issues that have already been decided by the FSEC?
Again, I think they perhaps touch a little bit on things like what conditions the council should include and things of that nature. I understand that this is mostly whether or not this is a land use issue, but in at least the second issue's regard, I do believe that they are relevant.
I think it can be framed in with those issues that have already been decided and established without challenging the underlying facts determined in that. I think you certainly make it an argument as to what the conditions should be in light of those. And I think that's something you can present limited to what the conditions the council should include, but not challenging the actual underlying facts themselves. So without telling you how I'm going to roll when you present those evidence or that testimony, you can certainly use that to frame how you're going to prepare your case.
Thank you. Understood.
Okay. Anything else, Ms. Holt, before we end today's pre-hearing conference?
No, sir.
And Ms. Anderson, anything else before we end today's pre-hearing conference?
I did, Your Honor. I was just looking for guidance or affirmation from you and the parties that filing electronically for all future pleadings is acceptable without the need to submit hard copies to everybody. That was my first follow-up question.
I will access the documents through FSEC SharePoint. So service to FSEC, and Ms. Hofkemeyer can confirm this, is acceptable through electronic service. Customarily, well, actually, before I get too far into this, Mr. Thompson, did you want to go ahead and respond before?
No, I don't have a response, sorry, to this point, but it raised another issue in my mind that I want to just put a bookmark in. So, sorry, go ahead with this topic.
Okay. Customarily in OAH proceedings, which is what I'm accustomed to working under, electronic service to the other parties is not acceptable unless there's a mutual agreement to do so. I do recall, I think it was in Mr. Carroll's, or perhaps it was Mr. Eisinger's, I'm not entirely sure whose notice of appearance, that electronic service was not acceptable. So absent agreement between those, I would ask that the parties submit service of the documents in accordance with the prescriptions that will be outlined in the pre-hearing conference. So with that long explanation, Ms. Holt, does Benton County, are you willing to waive the right to actual physical service and accept it uploading through the SharePoint to be acceptable?
Yes, sir.
You are willing to, and again, don't feel compelled. I'm not compelling one way or the other. I'm just, if we can nail this down now, it's easier because we're all here.
Yes, no, we're fine with electronic service.
Ms. Reinhold?
We are also fine with electronic service.
Okay, then Ms. Anderson, I think you have the answer for that one.
Very good. My only other area of two of clarification. On the pre-hearing briefs, the parties had discussed a limit that was consistent with the limit that was used in Horse Heaven, which is 15 pages of written memoranda, double-spaced, font size of no less than 12 points, and a prohibition on oversized briefs, but not the 15-page count would not include exhibits and attachments. It's a suggestion so that to the extent we start working on our briefs now, we know what the page limit and size are.
Customarily, I don't set a limit on pre-hearing briefs. The submission of exhibits within pre-hearing briefs is not, in my mind, appropriate because those exhibits at that point will not have been admitted into the record. So we do run the issue at that point of relying on information within your briefs as well for more than just argument. So given given the limited scope of the issues before us, I don't think it's necessary to set a limit, but I would ask that the parties also understand if you submit a brief that is too voluminous, there's a very strong possibility your lack of conciseness in your argument will be lost upon the parties reading it. So that's a decision you'll make as an attorney.
Great. Then last, I just want to get a clarification so that I understand. On the county's position, they are asking to recommend conditions that be placed on the permit to ensure that the permit considers local government interests on land use. Is that correct? And if that is correct, are they to look to the conditions that are included in the MDNS and advocate for those, or are they opening the book to everything?
It's a question directed to me or Miss Holt. I guess I'm not really sure who you're directing that question to.
I'm directing it, I think, to you. First of all, are the conditions limited to what will, I read issue 2 to say we are limited to conditions that reflect community interests on the topic of land use. And I was looking for affirmation on that, and then was asking whether or not those conditions are to be drawn from those included in the MDNS alone.
I think at this point, the way that the issues have been initially articulated, where the council should recommend to the governor that the state preempt the land use plans or other development regulations for the site. Hold on, that was the wrong portion. So are you asking if the scope of their arguments or presentation of their cases are limited to what's already been established in the NDMS?
Let me try again.
Rephrase your question. That's for that, and I didn't mean to get lost on it.
I think I can make this easier. The topic is the adjudication of the land use. Will their conditions that they wish to explore advocating for be limited to those that reflect the community interests? And I'm looking at issue 2, the community interests related to land use.
Ms. Holt, if you can chime in on that, I'm not really sure I'm comfortable opining at this point on that.
Sure. So I think community interest is certainly are going to be our main focus. However, we do not want to close the door on the other impacts, environmental, cultural, societal, if that's something that comes up in discovery and is relevant and it does not deviate from the prior adjudication.
I'm not sure what we're talking about the prior adjudication, first of all, so that would be helpful to clarify.
MDMX, sorry.
I see. Okay, I understand now. What you're saying is the conditions that reflect community interest, you're going to be looking to the MDNS and saying how those inform community interest in how this land is used.
I'm sorry, I couldn't hear you in the last part.
Let me take this off speaker and speak directly. What I think I heard you say, and I would agree, you are saying that the conditions that you wish to address on land use topics under land use issue 2 are those contained in the MDNS. Is that correct?
That is what we anticipate at this time, but I don't want to foreclose the door if additional things come up based on discovery.
And Your Honor, I would object to that. The topic that FSEC has defined for this adjudication is clearly land use. We're basing our schedule, we're basing the time that we need for adjudication on a land use adjudication. Reopening environmental, socioeconomic, cultural, and the like turns this into a multi-day, multi-topic adjudication that the council is not instructing us to perform. I would ask that the county's addressing of conditions be limited to those factors that speak to land use and how the conditions that have been put out by FSEC in the land use context reflect the county's and community's interests.
Okay, Ms. Anderson, I think at this point your objection is premature. Once the submission of the exhibits is, or the pre-hearing briefs and the submission of the exhibit lists are given by all parties, and we have an actual firm case of what people's presentations are going to be. Once we deal with the admission of the exhibits and potential witnesses, you can object at that point, and then we can revisit this. But at this point, I don't have enough information to limit what they may or may not present in their case.
Very good. Can we address at that time a continuation of the adjudication if the topics expand beyond?
If it's necessary, that's certainly something you can request. Yes.
Thank you. Thank you.
Okay. Anything else, Ms. Anderson?
No, sir.
All right, Mr. Thompson, you had something else you wanted to bring up. Please go ahead.
Yes, thank you. So this was just back to the topic of service, and I had received some calls from some of the counsel for other agencies that have the opportunity to participate in an FSEC adjudication, but who haven't exercised that right here. And they had received notices from the parties and were wondering what that was about. But so what I had told them is that my understanding would be that from this point forward, there wouldn't be a need to serve those other agencies anymore, since they have not indicated they'd be participating. So just want to make sure that's consistent with your
It does appear that everyone is amenable to filing all of their documents through the SharePoint or through the online portal with FSEC. I think that would still, if the parties still have access to that, then they still have access to documents without being inundated with documents that otherwise don't have a basis for. So I believe it is consistent.
Very good. Thank you.
All right. So at this point, I'm just going to open the floor to any other questions or anything else we need to discuss before we conclude today's peer hearing conference. Rather than name each individual, if you have something, go ahead and raise your hand, and I'll call you in the order that the hand is raised. Otherwise, we're going to go ahead and conclude today. Ms. Raineveld, go ahead, please.
Yes, I would just add that our understanding from Council for the Environment's perspective, at least according to my colleague, is that the issues are going to be defined and limited to the land use issues specifically stipulated within these issue areas. And if that broadens, then we may need to, I just would reserve the right for him to call additional witnesses. So did want to just raise that. And then in addition to that, I'm sorry, there's background noise. In addition to that, is there going to be a post-hearing brief deadline set, or will that be set at a later time, or did I miss that?
No, I didn't set it. I actually was going to wait until we get to the evidentiary hearing and discuss it at that point to see how long parties will need. I don't want to set an artificial date too far out if people are going to need less time than more. So we'll discuss it at the end of the adjudication.
Okay, thank you so much. That's it.
Very good. And as far as the concerns about the broadening of the scope, since the three parties in particular, are, at least in theory, collaborating to find those stipulated facts, at that point, the parties can discuss those concerns about the scope and the limitation of those issues which fall outside of the two issues that have been articulated. So hopefully by that point, everyone can reframe where we are with the issue. If not, I will take it up with any objections at the first part of the hearing. With this, and actually this bring, just a moment, please. Yes, you can in just a moment. I would actually like to set another date too, if everyone is available, to deal with pre-hearing matters such as the admission of evidence. I think having the evidence before the the council prior to the hearing would be beneficial, so they do have context. So I just wanted to put a pin in that, and then we'll get back to it after Ms. Anderson was going to add. Ms. Anderson, go ahead.
I would like clarification. Yes, I would like clarification from Mr. Thompson about how FSEC approaches the distinction between topics for an adjudication and issues for adjudication, because I raised a concern about this earlier and was affirmed by the council that the topic for this adjudication is land use. I keep path to reopen that absent somebody moving the council to do so. And that's the advice I got back from the council. So there's a difference between topic and issue, and perhaps Mr. Thompson can explain for the benefit of everybody on this call what that means, what the distinction is.
Mr. Thompson, if you're willing to answer that question, if you don't wish to, I'm not going to compel you.
Well, I don't want to. I don't want to step on your honor's toes either in terms of how you want to manage the scope of the issues. And I appreciate the point about not answering the question in the abstract if you don't have some specifics in front of you. But I would generally say that my interpretation is that that the topic is generally limited to whether the council should recommend preemption of land use regulations, and then if it does so, what conditions, if any, it should recommend to include as conditions of site certification to basically serve the purposes or the objectives of the preempted land use regulations. So that would be my interpretation of the scope, the intended scope of the
Ms. Holt,
adjudication.
thank you. Ms. Holt, in reviewing what we're looking at, the what condition should include. I don't. Again, we're a bit early in the proceedings to really see what your case presentation is going to be, but to have witnesses provide factual testimony that are contrary to the NDMS, I can tell you at this point, I'm very strongly going to not allow that testimony, as those have been established. That these considerations in light of the NDMS may be better suited for legal argument in a post-hearing brief or pre-hearing brief as to how those would work in after for that second issue. You certainly can raise you can attempt to tell me and the other parties why substantive testimony on those is necessary for that second one, but at this point I'm not seeing it. So, but again, I'm uncomfortable making rulings on the abstract without seeing how it plays in. So that's something we'll pick up at a later date. But please keep that in mind in the case presentation.
Understood, sir.
Okay, now let's getting back. We'll go around the horn one last time before, but we're pushing the end of where we are today. I would like actually to meet ahead of the evidentiary hearing to deal with any pre-hearing issues, so we're not shortening the time we have for the presentation of the case as we narrowed it down to 1 day. I would like to meet sometime, preferably between the voluntary hearing brief and the actual evidentiary hearing on the 25th, for a couple hours to deal with the pre-admission of the documents and any other thing we need to discuss. And this is going to be, as far as I understand, just the three parties: Benton County Council of the Environment, Interjex, FSEC, 4 parties, and then myself. Ms. Anderson, if we meet for 2 hours, sometime between the 18th and the 25th, would you be available to discuss or to take up the evidentiary rulings?
Yes.
Okay.
I can be available any of those days.
Okay, thank you for that. Then we'll see who has limitations and we'll work backwards from there. Ms. Holt, could you meet for 2 hours sometime between the 18th and preferably the 24th to deal with those pre-admission?
I can make most times work between the 18th and the 24th. Yes.
Ms. Randall?
Yes, it seems like Yuri has, Mr. Kroll has some availability in that window. And we're talking about September right before the hearing. Is that correct?
Yeah, it is. Yeah, I just want to, like I said, I want to take care of everything before we get to the hearing and just hit the ground running once we start.
Okay, yeah. Friday
Okay,
is
Ms. Hofka?
free.
I'm sorry.
Friday
you broke up.
Oh, Friday the 20th looks very free. Just FYI.
Okay, I probably should consult with my calendar too. I haven't been doing that. Yep, Friday the 20th is available for me too. If we did it from 9 a.m. to 11 a.m. on Friday, September 20th, Ms. Anderson, could you participate at that point?
Let me grab my calendar. From 9 to 11, that certainly works.
Excellent. Ms. Holt, would that work for you as well?
Yes, sir.
Very good. Ms. Hofmar, does it FSEC anticipate participating in the pre-hearing matters?
We would likely sit in to be aware.
Okay, as long as there's no one actually from the council present, because we may be discussing stuff that otherwise won't be before them. So I just need to put that out there that I don't want them exposed to information that may otherwise not be admitted.
It would be people on the call today, technical and support staff.
Okay, very good. All right, then we'll set it for the second pre-hearing conference for admission, September 20th from 9 a.m. to 11 a.m. All right, so one last final opportunity to go around the board to discuss new matters or things we need to talk about before we conclude. One last chance. Ms. Anderson, we'll begin with you. Anything else before we close up today?
No, sir. Thank you.
Ms. Holt?
No, sir. Thank you.
Ms. Randall, Ms. Hafkamar, we'll get to you in just a moment. Ms. Randall?
Nothing further, Your Honor. Thank you.
Ms. Hafkamar, please go ahead.
For the previous adjudications, filings were sent to our adjudication email, adjudication@fsec.wa.gov, and then shared with the judge through the SharePoint. I don't know that all the parties have access to our SharePoint, so I would anticipate that we would want filings to be received the same way.
I don't have access to the SharePoint. Anderson?
Ms. Taliaferro, I know you handle the SharePoint. Did you want to add?
Yes, I just wanted to, I agree with Amy Hafmeyer, the way that we did it in the Horse Heaven, which is our most recent adjudication. Filings were received via email at that email address, and then also served on the other parties via email. And then just for you to access to the SharePoint site would be only for internal use and for the judge.
Okay, the parties can coordinate with FSEC independently on accessing the SharePoint. That's something beyond my purview. I will consult with FSEC and including the language for the service in accordance to their practices in my pre-hearing conference order. So everything we discussed today within the limitations of my authority will be included in that pre-hearing conference order. Okay. Anybody else have anything else we need to discuss before we conclude today? If so, go ahead and raise your hand. Otherwise, we're going to adjourn for the afternoon. Okay. So with that, thank you all for your patience and participation. I will issue my pre-hearing conference order. That will be mailed out to all the parties as soon as possible. Any party will have 10 days from the issuance of that pre-hearing conference order to object. If that does occur, we will set a status conference to deal with those objections and any responses and potential impacts on the case schedule. The time is 2:39 p.m. and the pre-hearing conference is adjourned. Thank you all for your participation and have a good afternoon.
Thank you. Have a good day.
Thank you.
Bye.
Thank you, everybody.